A National Assembly Speaker Nosiviwe Mapisa-Nqakula has cautioned Chief Justice Raymond Zondo about making remarks which could lead to his impartiality being questioned. It comes a day after a meeting was held after he alleged Parliament for failing to take action to prevent state capture from repeating itself. Zondo provided 3 solutions, including electoral reform, the establishment of an anti-corruption commission within the Presidency as part of the measures needed. Accountability Now Director, Advocate Hoffman, is joining us now to give us his views. Advocate, good to have you. Thank you very much for coming on tonight. The Chief Justice comes on a year later and he says, looking at Parliament right now, he doesn't believe, for example, that they would be able to save the country from another episode of state capture were it to happen. Parliament obviously not happy about that. Come out lashing out the judge's comment on his report, and it ended up in a meeting. Let's start here. The concerns being raised around the implementation of the report. Are these valid concerns? Are they justifiable concerns for the Chief Justice to raise? And maybe we can talk about the platform in which he chose to raise them.
Yes, I think, thank you for the opportunity. I think that it's very clear that the Chief Justice went to the colloquium organized by the HSRC in his capacity as the chair of the Commission of Inquiry into State Capture. And in that capacity, he's perfectly within his rights to follow up on his report exactly a year after the report was handed over to the President. In that year, the Presidency has had a very good look at the report and has recommended that Parliament accept those recommendations made by the Commission of Inquiry as far as they relate to Parliament. And what the Chief Justice said, wearing his Commissioner hat, not his Chief Justice hat, was that in his view, democracy is at risk in South Africa because he does not believe that Parliament will behave any differently this time round to the way in which it behaved when inquiries into what the Guptas were up to were basically stonewalled by the ANC majority in Parliament. Now, it's very clear that Parliament has not done what needs to be done in relation to the implementation.
Why do you say so, Advocate? They say 11 out of 19. You don't think that's a good score? I mean, if you were to be marked 11 out of 19.
Look, let's cut this to basics.
Yeah.
The major causes of the state capture phenomenon in the Zuma years were first that Parliament was asleep at the wheel. There were no proper anti-corruption measures, no proper anti-corruption machinery of state in place in South Africa. And as a consequence of that, the criminality that goes into state capture, the kleptocracy, the serious corruption, was allowed to happen. Nothing has been done about addressing that basic problem. And it's not as though it came as a great surprise to hear in the middle of last year that the problem was that South Africa does not have the wherewithal to counter serious corruption. Parliament itself has had draft legislation and a draft constitutional amendment from Accountability Now since August 2021.
Yeah.
In August 2020, the National Executive Committee of the ANC passed a resolution calling on Cabinet urgently to establish an independent, standalone, specialist body to deal with corruption. And Cabinet has ignored that, and Parliament has allowed Cabinet to ignore that. If we go back further, you will see that in the Glenister litigation, the highest court in the land spelt out for Parliament what needs to be done to have effective and efficient anti-corruption machinery in South Africa. And it's quite clear that we don't have that, and that what is happening in relation to the investigating directorate of the NPA is not constitutionally compliant and will not cut it when it comes to dealing with state capture Mark II, which is why the Chief Justice was perfectly justified and well within his rights to stand up in public and say, pass up, there's problem coming.
Let's aggregate this data again and distill it a little bit more. The Commission comes out and recommends that, look, find a way to protect members of Parliament and provincial legislatures from losing their seats if they don't toe the party line, right? We're hearing today from the presiding officers that, no, they looked at this, they did research, and they looked at, I suppose, best practice everywhere else in the world, and looked at our Constitution, and they feel there's enough in the Constitution to protect members of Parliament and members of legislature. So there is no new intervention that is required right now.
Now, the truth is that Parliament is in the thrall of the executive. Everybody, certainly the majority members of Parliament, all aspire to get promoted into the executive, and they all know that if they are not towing the Latuli House line, they stand the prospect of being relieved of their position in Parliament. So the executive dominates Parliament, whereas Parliament, in terms of the Constitution, is meant to be holding the executive to account and is meant to be ensuring the proper implementation of the laws that it passes. Now, that hasn't been happening, and it won't happen while this wall-to-wall proportional representation situation in a dominant party state continues. It may be that at the next election, the voters will address the problem. But tinkering with the status and the term of office of parliamentarians and provincial members of provincial parliaments is not going to solve the problem that the Chief Justice was addressing at the colloquium, which is that the criminality involved in state capture is still at large in South Africa, and that Parliament has not shown any sign of being prepared to do anything about it.
So, Chief Justice says overhaul the Intelligence Services Act. In other words, those who are leaving that particular portfolio committee after whatever, a 5-year term, should be able to come and report to Parliament about some of the work that is being done there. The reason is because the budget of intelligence ballooned from 42 million in 2016-2017 to 300 million in 2017-2018, and nobody really knows what is happening there. Well, we hear that there is no amendment necessary at this particular point. In fact, what we are told is that there'll be some boosting of administrative capacity. I'm not quite sure what it means. Does it make any sense to you?
The State Security Agency was repurposed to look after Mr. Zuma and his friends during the Zuma era. President Ramaphosa succeeded Zuma in February 2018. It is now June 2023, and we still do not have the structures that are required. The operational and structural independence of the anti-corruption machinery of state ought to be guaranteed in terms of the Glenister rulings, and the Glenister rulings are binding on Parliament and on the executive branch of government. Nothing is being done to put in place the type of I call them the super scorpions sometimes, because that reminds people that we once had a unit that could do the job, but was not sufficiently protected against the ravages of the Zuma administration, and could be closed down by a simple majority in Parliament, and was in fact dissolved because Mr. Zuma did not need scorpions breathing down his neck. And the ANC allowed that to happen, They elected Mr. Zuma and they did what Mr. Zuma wanted to do. There's nothing that has happened since then that suggests that that sort of error could be perpetuated again, and that state capture Mark II is in the offing. That is why the Chief Justice was prepared to stand up in public and to say what he said at the HSRC colloquium, and to suggest that his impartiality is brought into question is not to understand that because he sat in that commission of inquiry, he will never sit in any case that has anything to do with state capture. He cannot. He won't. And that really cuts the ground out from under the complaint that the Speaker of Parliament has aired against him without any justification at all.
So we are told today that as South Africa, we must believe, and they're emphasizing that. We want to emphasize that Parliament, through the diligent efforts of the Programming and Rules Committee, have taken decisive steps to address the recommendations of the State Capture Commission. They got these in October last year. They're saying by January they had put together a task team that developed the implementation plan and came up with how they're going to carry this out. We've touched on the areas that they say they've changed and how much they've changed that. For example, if we look at the question of MPs that have been fingered in the report, they say some were cleared, I think 3 of them, others are still under consideration. Is this consistent with what they are saying, that they are committed to diligently take decisive steps to address the recommendations?
The matters you're talking about, Thabo, are really the frilly bits around the edge and matters of historical interest. What South Africans need to be concerned about now is that nothing has been done to fix the broken criminal justice administration's capacity to deal with serious corruption by preventing it, by combating it, by investigating it properly so that trial-ready dockets are prepared, and by prosecuting it efficiently and effectively. If we don't get that right, there is absolutely no reason why corrupt people should not continue with their corruption with impunity, because there is nothing to deter them from doing so. And you can move the deck chairs around on the Titanic until you're blue in the face. The Titanic is still going to sink if we do not address the core issues. The one is the lack of anti-corruption machinery, and the other is the toxic practice of cadre deployment in the public administration and in the state-owned enterprises, where instead of serving the people of South Africa, the deployed cadres serve the interests of the party bosses at Luthuli House. That is a really big problem.
Advocate, appreciate your time. Thanks for coming on. That's Director of Accountability and now Advocate Paul Hoffman.